This is a lecture about Model Rule 2.3 for my professional responsibility class. This is actually a remake from an earlier video that I did about this rule. So Model Rule 2.3 is about evaluations for the use by third parties. And just to kind of make clear to my students what's going on with this rule is a little bit long and has a lot of comments, and I think it's confusing. And so let me explain what's happening. This normally occurs in transactional settings, and a client may ask you to prepare a report about your client. So for example, an audit of their business, or a summary of outstanding liabilities, or an investigation into the chain of title for a particular piece of property that your client is going to turn over directly to another party, like the buyer of a business or a lender. Those are probably the two most common scenarios. It could be a regulatory agency. And sometimes the client will ask you to just prepare the report and send it in, and they don't even need to check it first. So before we go through the kind of tedious wording of the rules, here's the bottom line. Number one, if there's something that you uncover that's going to be in the report that's unfavorable to your client, you need to check with your client and explain the situation before you submit the report. That kind of, I hope, makes sense. On the other hand, if the client says, leave that out, or change the numbers, or do something that you know is fraudulent, you're not allowed to do that. So you're not allowed to commit fraud, but you're also not allowed to send along a report that has some pretty unfavorable or damaging information about your own client without double checking with your client. And so in a sense, this is a double checking rule, but we're talking about this weird scenario where the recipient of your legal work, of your work product, is a third party, but your client has hired you to do this. So having said that, let's go back to and work through the rule itself. A lawyer may provide an evaluation of a matter affecting a client for use of someone other than the client, a third person, if the lawyer reasonably believes that making the evaluation is compatible with other aspects of the lawyer's relationship with the client. B, when the lawyer knows, or reasonably should know, that the evaluation is likely to affect the client's interests materially and adversely. So we're talking about something serious, not something trivial, and something negative. The lawyer shall not provide the evaluation unless the client gives informed consent. That means you have to check back with your client and follow their instructions. C, except as disclosure is authorized in connection with a report or an evaluation, information relating to the evaluation is otherwise protected by Rule 1.6. In other words, in the process of information gathering and research to prepare this evaluation, you're going to learn additional information that you didn't even put in the report. Sometimes the attorney for the other party, let's say it's a commercial bank, a commercial lender, may call you and say, hey, is there anything else we should know that's not in the report? And at that point, you have to invoke your duty of confidentiality to your client. Okay, let's talk about the comments. An evaluation may be performed at the client's direction or when impliedly authorized in order to carry out the representation. I'm going to give you a quick example of implied authorization. You did estate planning for the client, and now the client has become incapacitated or has passed away, and you are the executor of the estate, and so you need to liquidate some of the properties and assets, in which case, and that could involve preparing reports for prospective buyers. And that in that case, it would be impliedly authorized in the representation. Usually, though, the scenarios you will get on the MPRE, and I guarantee you will have at least one and maybe two questions about this rule, and they will be difficult. They will normally be about an express direction from the client. Some evaluations may be for the primary purpose of establishing information for the benefit of third parties. For example, an opinion concerning the title of property rendered at behest of the vendor for the information of a prospective purchaser, or at the behest of a borrower, and that would be your client, for the information of a prospective lender, like a commercial bank. In some situations, the evaluation may be required by a government agency. For example, an opinion concerning the legality of securities registered for sale under the securities laws. So your client may say, look, I want to offer these. We have to file compliance reports with the SEC or prospectus with the SEC. Of course, they're going to ask their lawyer to draft that. In yet other instances, the evaluation may be required by a third person, such as the purchaser of a business. So if you're doing mergers and acquisitions, this is also going to be part of your life. A legal evaluation, this is comment 2, should be distinguished from an investigation of a person with whom the lawyer does not have a client-lawyer relationship. And so let's reverse the roles for a moment. And by the way, some of the questions on the MPRE are this scenario, and that should be easy. That should be a softball question. The lawyer is retained by a purchaser to analyze a seller's title, a vendor's title to property, does not have a client-lawyer relationship with the seller. Always ask yourself, who hired the lawyer? Who actually hired the lawyer? That's the only one that the lawyer has a duty of confidentiality to and has to check with. And so a quick example, your client says, I'm interested in buying this commercial building. I'd like you to research the chain of title and so forth, and do a title search, and maybe an environmental assessment or something like that. And in your contact with the current owner who's hoping to sell the property, they inform you that there are some underground oil tanks from decades ago that have been abandoned and could be leaking, but they don't think about it. And then they say, but that's off the record. Please don't put that in your report. Well, if they're not your client, they don't get to tell you what's off the record or what goes in your report. So also an investigation into a person's affairs by a government lawyer or by special counsel employed by the government is not an evaluation as that term is used in this rule. In other words, this rule does not apply to things like the Mueller investigation or the Mueller report and so forth. The question is whether the lawyer is retained by the person whose affairs are being examined. And so this comment right here is the one you really need, the fundamental question for answering test questions. Comment 3, when the evaluation is intended for information or use of a third person, a legal duty to that person may or may not arise. This is going to depend on the type of case, the type of contractual obligations between the other party, and state law about reliance and so forth. That question is beyond the scope of this rule, and which means in turn, you don't need to be able to answer that question about a legal duty to the third party for purposes of the MPRE. Even so, since an evaluation like this involves a departure from the normal client-lawyer relationship where you would primarily be giving information to your client, careful analysis of the situation is required. The lawyer must be satisfied as a matter of professional judgment that making the evaluation is compatible with other functions undertaken on behalf of that client. So the client hires you to do an evaluation of the client's affairs for a third party, let's say, but there's a problem. So if the lawyer is acting as an advocate and defending the client against charges of fraud, it would normally be incompatible with that responsibility for the lawyer to perform an evaluation for others concerning the same or related transaction. So for example, a corporation is in trouble with the SEC or the Federal Trade Commission, let's say, and they hire you to do an internal audit, and you're also going to be advocating for them, defending against an enforcement action against the government. Well, you shouldn't be trying to defend them and be the person responsible for providing a report about your client that the other side can rely on. They should really have different lawyers for that. Please note, this is not exactly a conflict of interest that we're talking about here. This is you trying to do sort of conflicting roles or mutually exclusive functions for your client. Now, assuming no such impediment is apparent, however, the lawyer should advise the client of the implications of the evaluation, particularly the lawyer's responsibility to third persons and the duty to disseminate the findings. So if you think about it, we have some statutes like Sarbanes-Oxley and similar mandatory reporting or whistleblower statutes that may be implicated. And you need to tell your client about that before you undertake the evaluation. Because a lot of your clients are just going to assume that they can say, oh, no, 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 don't put that in the report. Now, the quality of an evaluation depends on the freedom and extent of the investigation upon which it is based. If your client is hovering over you, grabbing the pen out of your hand and saying, don't put that in the report and so forth, then what was the point of the other side asking for a report prepared by the lawyer? They could just ask your client directly. The idea was that the lawyer would prepare something that other parties could rely on and that's sort of been certified, I guess, as truthful and honest. So the lawyer should have whatever latitude of investigation seems necessary as a matter of professional judgment. And under some circumstances, the terms of the evaluation may be limited. So address this up front. In other words, if you know that your client did something bad way back when, propose that the report will only begin like 2 years ago from the time period, the time window 2 years ago until the present. Or limit the scope, like you're only looking at outstanding liabilities, not potential or theoretical liabilities or something like that. Certain issues or sources may be categorically excluded, or the scope of the search may be limited by time constraints, or the non-cooperation of persons having relevant information. So it could be that you simply weren't able to get reports from a party, maybe not your client, but a former employee of your client, a former partner of your client who's not cooperating or not on speaking terms with them anymore. And you're going to have to put that in the report. Any such limitations that are material to the evaluation must be described in the report. So what we're really talking about here is you're not allowed to lie for your client by omission when you're preparing reports for third parties. And if you are, just to kind of go off slide for a moment here, so if this is for a commercial lender or for a prospective buyer of your client's business, and you're limiting, there's certain things that you are not going to talk about in the report. At the beginning of the report, you should say, this report doesn't address this, and you don't have to disclose the unfavorable information about your client, but you have to say, we're only talking about this and we're not talking about that. And if you, with the implication, if you wanted that, you're going to have to ask for another report, and we're going to have another discussion with my client about it. Okay, so let's go back. We're almost done and finish talking about the comments here. If after a lawyer has commenced an evaluation, the client becomes uncooperative and refuses to comply with the terms upon which it was understood the evaluation was to have been made, the lawyer's obligations are determined by law, having reference to the terms of the client's agreement and the surrounding circumstances. In other words, the ABA isn't giving you a lot of guidance here, except in no circumstances is the lawyer permitted to knowingly make a false statement of material fact or law in providing an evaluation under this rule. You are not off the hook. You don't get to say to the bar, well, the client told me to lie in the report, or the client told me to put that in, or the client told me to leave that out. The report must be truthful, and you have to check with the client. And if the client says, no, you can't put that in the report, you may have to withdraw or somehow work things out with the client, but you cannot under any circumstances assist the client in committing a crime or defrauding others. And that's stated in other rules too. So this is something that carries through the model rules. Comment 5. Information relating to an evaluation is protected by 1.6. We already talked about this with 2.3c. That's what this comment is about, where it's reasonably likely that providing an evaluation will affect the client's interest materially and adversely. The lawyer must first obtain the client's consent after the client has been adequately informed concerning the important possible effects of the client's interests. And so, for example, I'm going to give you a very common example. You can say, look, I've learned there's certain things here, and if I put them in the report, it's also your insurance carrier may drop you or may raise your premiums, even though we're giving this report to someone else when they find out about it, because now it's going to be out in the open. Conversely, if in preparing this, you find out a whole bunch of other information that doesn't have to go in the report, that information, as you might expect, is still going to come under your duty of confidentiality to the client, and you won't have to disclose it. and you should refuse to disclose it if other parties ask you for it. Okay, that ends our presentation about our little lecture about Rule 2.3.